This is petition number 1458 concerning a register of judicial interest. This petition comes from Peter Chirby calling on the Scottish Parliament to urge the Scottish Government to create a register of pecuniary interest of Judges Bill, or to amend present legislation to require all members of the judiciary in Scotland to submit their interests and hospitality received to a publicly available register of interests. And again, I refer members to the relevant papers which have been sent to us, including papers from supporters of the petition. Like the previous petition that we've just considered, the committee has had this petition in front of it for a long time, and the petition itself was lodged in December 2012. Now, I note that the last time that the committee considered this petition, the committee agreed to seek some further information on other potential conflicts of interests relating to key stakeholders in the Scottish judicial system, and also to hold a round table on the matter with constitutional and academic witnesses. Now, I'm afraid that pressures of competing work has meant that we have not been able to organise a roundtable on this subject, and so that remains undone. I'll open the floor to members at this point for their views, and again, as with the previous petition, we need to decide if we are closing the petition or whether we wish to keep it open for session 6, and again, as with the previous petition, if we take the latter course, we need to justify why this is the case. A number of members have indicated that they would wish to speak about this, and I'll ask Annabel Ewing first, to be followed by Liam Kerr, please. Annabel.
Thank you, Convener. And again, I'm mindful of the fact I probably should have waited for my colleagues to put their R in the chat box first, because as a new member of the committee, or newish, that might have been more appropriate. But in any event, I have read the clerk's note on this, and I have peripherally been aware, obviously, of this petition over the course of some years. I would cite a few things. One, as far as I can see, the statement of principles of judicial ethics is a very comprehensive set of requirements, and that's point number one. So the idea that there's nothing there is, to me, just a fallacy. Second, I note indeed that there have been additional safeguards put in place during the period of this petition, and I would cite the register of recusals and publication of judicial expenses and overseas travel. And thirdly, and perhaps most importantly, I was also very struck by the letter from the Lord President, and the key thing that struck me was the need for the independence of the judiciary. And, it's not comparable to, any old other profession. It's the judiciary of this country, and the independence of the judiciary is a fundamental tenet of our laws and our society. And I therefore agree with the Lord President on these matters, and I would not support the continuation of this petition. Thank you.
Thank you very much, Annabel. The record won't show this, but I was nodding vigorously through what you were saying there about the fundamental importance of the independence of the judiciary as a tenet of the separation of powers, which I think is the principle which needs to be borne front and centre when we consider questions such as this. For the record, I might add, if I may, that bringing a register of judicial interests essentially would need either the Lord President to set this up himself, or for Parliament to legislate to do so. The Lord President has said, as Annabel Ewing has just referred to, that he does not see the need for such a register, and that is also the view of the current Scottish Government, who have said that they do not support such a register. I'll take other views. Liam Kerr, please, to be followed by Liam McArthur. Liam.
Yeah, thank you, Convener. For complete transparency, of course, I'd make the usual declaration that I'm a member of the Law Society. I listened very carefully. I think Annabel Ewing and yourself speak very persuasively. I think this is an interesting debate. I sit here thinking, I'm not convinced that I've heard a convincing argument against this as yet. I listened to you two, and I think there's something there, but I need to hear more. I also, given some of the debates that have been happening recently that you and I particularly have been involved in, Convener, that just gives me pause for thought about this petition. But for sitting here where I am right now, you prefaced your comments by saying, look, the previous Justice Committee was interested in hearing more information about this. We did talk about having a round table. And so where I am right now is I feel that there is more that I want to hear about this. There's more I want to learn before I decide what I think about the Register of Interest. And for that reason, right now, I would be inclined to keep the petition open with a view to perhaps myself, but whoever has the privilege of coming back here and being on the Justice Committee, looking again at this in the cold light of day of the new session.
Okay, thank you, Liam. Annabel Ewing has asked me just to remind members that she also is a member, like Liam Kerr, of the Law Society of Scotland, although, again, like Liam Kerr, she's never been, or not yet been, on the bench. Thank you, Annabel. Liam McArthur, please.
Thanks very much, Convener. I have no such declaration to make. I mean, I would agree wholeheartedly with what you said, Convener, and indeed what Annabel Ewing said in opening this debate. I think it is indisputable that there have been steps taken to address at least some of the principles of the concern that is raised through this petition. I think where I'm slightly anxious, and here I would refer back to Annabel Ewing's comments in relation to the earlier petition about the value and the benefits of consistency, having assisted the petition previously on the basis that the committee was going to hold a round table to solicit wider views from stakeholders. Having not done so, I think it would be difficult to make an argument for why we would then close it. Again, it would seem to be for administrative neatness. Now, it's a commitment I think that we made as a committee. If the incoming committee after the next election doesn't feel as if it needs to be beholden to that commitment, that's a decision for it to take. But I think it would be passing strange for us to have come to that conclusion the last time we considered the petition and then simply abandon that with the prospect of an election looming. And I think on that basis, I would be minded to as with the earlier petition, to keep this one open until the next session.
Okay, thank you very much, Liam. Rhoda Mackay, please. And after Rhoda, it will be John Finnie. Rhoda.
Thank you. Yeah, I was on the Petitions Committee where this petition started its journey before it came to Justice. And I'm actually really supportive of it, and I'm on record as saying that. However, given that the Lord President and the Cabinet Secretary have made their views clear on it several times, my thoughts would be that at this stage we should close it, always with the knowledge that the petitioner can bring it back in the next session if he wants to carry on with it. I don't think we're being inconsistent. I think it's different from the previous petition that we've decided to keep open because the circumstances are different. My preference would be at this stage to close it, and the petitioner can always bring it back, although I am sympathetic to the subject.
Okay, thank you, Rona. John Finnie, and then after John, it will be Shona Robison, please.
Yeah, thank you, Convener. Following on for your own comments about the separation of powers, and of course in any liberal democracy, absolutely vital that we have an independent judiciary. I accept that. However, we are talking about one individual. Now, I don't know the individual that is the Lord President. I have no axe to grind one way or another. But let me paraphrase what previous exchanges have been. No, I don't want it. Well, let's write him again. I've already told you I don't want it, so I'm telling you again I don't want it. Discussions about coming to give evidence and discussions whether it was even appropriate to ask to come and give evidence. Well, I could come and get evidence, but as I've told you, and I'll tell you for the third time, I don't want it. That doesn't seem to me like a functioning liberal democracy, to be perfectly honest, because what is there to fear from disclosing the information that's asked here? There are examples given in other jurisdictions where this is not problematic at all. So should we be surprised that a government of whatever persuasion wants to be in accord with the Lord President, doesn't want to have dissent from the Lord President's position? Perhaps not. So I'm not persuaded by either of these two arguments, but the most compelling most compelling reasons why we must keep this open, and I'm supportive, as I say, I declare support for the intention of the petition. The devil, as always, will be in the detail. But of course, the detail that we've had shared with us is that are urging us to commission the work we already decided. This is very clearly unfinished work for the committee. We undertook to do things in relation to this petition. We haven't done that. And for that reason, we must pass it on to the next committee to pick up on that work, and it'll be for them to decide how they go thereafter. But it should be maintained open. Thank you, Convener.
Okay, thank you, John. And the last member who's indicated that they want to speak on this is delete that. Shona Robison will be next, please, and then after Shona will be Rhoda Grant. Shona.
Thanks, Convener. I don't have any really strong views about this, I have to say, and I do have some sympathy with Annabelle Ewing's comments about the additional safeguards, and of course I think we all agree about the independence of the judiciary. However, I do have some sympathy with what John Finnie has said as well, in that we should be consistent, and if we feel there is some unfinished business here for the next committee to take forward, even if it is just about a round table and gathering some further evidence, which the committee at that point would then be in a better position perhaps to make a definitive call on whether or not there's more that should be done here. So I hope we can reach a consensual agreement this morning on this, and as I say, I think I would be content with it being included in our legacy report as something for the next committee to consider further.
Okay, thank you, Shona. That's very helpful indeed. And Rhoda Grant, please.
Just very briefly, I agree with what John Finnie said and proposed.
Thank you, Rhoda. Okay, listen, so I think that's been a very helpful debate, colleagues. I'm grateful to you. My sense of this discussion is that members of the committee do not feel as strongly about this petition as they did about the previous one. There has been some modest and minor disagreement expressed by members of the committee about whether to keep the petition open or whether to close it, but I think the balance of opinion is in favour of keeping it open, if only because there is a sense of unfinished business here. However unfinished the business is, though, I think everybody who has expressed a view about the matter is very clearly of the view that that business needs to be transacted subject to and in the light of the fundamentally important principles of the separation of powers and the independence of the judiciary. But I think that the body of opinion is that the petition should not be closed at the moment, but that our successor committee in session 6 should be invited to consider the matter, if only to hear views and perhaps to explore a little bit about why the Lord President is opposed to, or indeed why the judiciary, represented by the Lord President, are opposed to the creation of such a register. But I would just close, if I may, by saying that just because it's appropriate for elected members in the legislature to have a register of interests does not mean that it is appropriate for members of the judiciary to have any sort of similar register of interests. That is the function of the separation of powers, to treat different branches of government differently according to their institutional function. So that, I hope, is a fair summary, albeit with a gloss from me at the end of the committee's decision. And that completes our consideration, colleagues, of public petitions.